Good afternoon, everybody. My name is Mario Meeks. I am the White Collar Criminal Policy Counsel at NACDL. And thank you for joining us today. This is the latest installment of our White Collar Crime Summer Series. It is entitled Defending Federal Crimes. It is a follow-up to last year's successful series, which was called Tax Crimes 101. Before I go into introducing the panelists, I've been asked to do a plug for our upcoming East Coast White Collar Conference. That conference is October 27th and 28th. That's a Thursday and Friday. It is in Washington, D.C. It's at the Crown Plaza Hotel. The address is 1001 14th Street. If you're interested in finding out more information, please go to our website. Okay, all right. Now, if I could introduce our esteemed panelists we have here today. We have, back by popular demand, we have Thomas Zehnle, who did the successful seminar last year. He is a partner at Miller and Chevalier. He has over 25 years of experience working on the federal tax criminal matters, including his time as a section chief at the Department of Justice, where he oversaw numerous prosecutions of tax crimes. And we have the one and only Paula Junghans. She has over 35 years of experience working on federal tax criminal matters as well. She also has been deemed by the Washingtonian as one of the 30 best lawyers in DC, and she was also deemed a complete superstar by Chambers USA. So we're very happy to have her here today. As to the actual format of the panel, we're going to let the panelists do their presentation. At the end of that, we're going to open it up for brief Q&A. If you have any questions, please send them to me directly. My email is mmeeks@nacdl.org. Again, that's mmeeks@nacdl.org. And with that said, let's begin.
Thanks, Mario. Appreciate it. So, as you just heard, this is essentially the follow-up to last year's summer series, which was Tax 101, or Criminal Tax 101, which dealt with a lot of the basics of criminal tax matters, where we talked about the particular tax crimes that the government generally charges, the elements of those crimes, and some basic understanding of the procedures that are specific to criminal tax matters. So while we might refer a little to that, in terms of things that we might have covered last year, this year's program, obviously with Paula involved, is going to be a little more, I would call 201 or a 301 level course. We're going to try to be a little more nuanced and focus on some selected issues with respect to criminal tax cases. So the way it's going to work, we've picked out 4 topics that Paul and I have discussed, and we'll probably end up jumping in on, as we discuss these matters. But we're going to do it kind of in the order that you would expect to see it if you were handling a criminal tax investigation and a criminal tax trial. So the first thing we want to talk about, and I'll try to move these slides along, but I'm not going to be wedded to them. I never am, but we'll try to keep in focus with these things, at least in terms of the topics of discussion. So the first selected topic that we wanted to talk about was the tax division process or procedure for having conferences. Now, again, as I said a moment ago, I'll put this in context just in case certain people who are listening in or in the room didn't hear last year. So just to give you a little bit of the background of how these things come up. So in general, criminal tax cases arise in one of 2 ways. Either through an administrative investigation, and by administrative investigation we mean essentially IRS special agents who are conducting their inquiry on their own without a U.S. Department of Justice Tax Division prosecutor or an assistant United States attorney assisting them. So it's all being done on the administrative or agency side of things. And
which is pretty rare these days.
which is becoming much more rare. And the second way that tax investigations and tax prosecutions are brought are generally through grand jury investigations, which is not dissimilar to what other people see in typical white-collar criminal cases. So, and I'll get back to why I wanted to just touch on the administrative versus grand jury investigation in a moment. But unlike most white-collar cases, to bring a criminal tax investigation and a criminal tax prosecution at the federal level, you have to get it cleared through Washington, D.C., through Main Justice, the tax division. And the reason, just to kind of give you a flavor for it, is that tax crimes and taxes in general, as we all know, tend to impact hundreds of millions of people, entities, etc. And so it's a lot different than, say, a run-of-the-mill fraud case where one person defrauds another of money. The fact is, you don't want to have, at least the theory is, you don't want to have criminal tax cases being brought, say, in Alabama, and then next door in Georgia, no one's bringing any cases with respect to criminal tax matters. Or when those cases are brought, and I'm just using Alabama and Georgia as examples, you don't want one particular jurisdiction to essentially say, yeah, well, it's just a tax crime, no big deal, you know, let's go probation, and then the judicial district in the neighboring state saying, no, these are very serious, you're going to do, 48 months in federal prison. And so the whole idea of centralizing the review at DOJ is understanding that it's a sophisticated area. Taxes involve accounting concepts, financial concepts that aren't always present in other white-collar cases, and that you want a certain uniformity in the way that those laws, which apply to just about every American, except for the young who don't pay taxes, it affects them. So that's why it's centralized. So how does this work? You got to get approval through Washington. Whether it's an administrative investigation where the IRS agents bring it, or whether it's a grand jury investigation led by an AUSA with the assistance of IRS agents. Once they get their case together, they package it up, put their evidence together, write PROS memos, or write SARs, I should say, special agents reports, and they send them to DOJ for review and authorization, let's just say in this case, to bring a tax prosecution. In doing this, in looking at the cases and selecting the cases that the government is going to bring forward, the Department of Justice Tax Division allows the taxpayer to have what is known as a tax division conference. And the tax division conference, let's see, we'll go on, is held here in Washington, D.C. The way you request it, if you're the counsel for the taxpayer, is you send in a letter requesting a formal conference. And if it's a grand jury investigation, you should expect that it's at least possible the Assistant United States Attorney who's investigating the matter might also be present at that conference.
Can I just jump in here for a second?
Please.
My practice, and has always been, that you send the conference the minute you get hired. The case may not ripen for 2 or 3 years, but that way you don't have to wonder about, am I sending it at the right moment, or will they get it before they make a decision? You send it as soon as you can. I've had people say to me, well, isn't that going to make the tax division somehow think that I think that my client is guilty? And the answer to that is no. This is just a routine ministerial thing. It gets put in the tax, or at least in theory, sometimes these things fall between the cracks, but in theory it gets put in the tax division's computers associated with the name of that person. And then when and if the tax division ever gets a file, they look in the computer and they see that the name is there and that there is a conference request. Because if you wait too long, you could send in a request and they'd say, sorry, that was authorized 2 weeks ago. So I think sooner is always better than later.
And I would echo those comments as well. So the whole purpose of the conference is really, it gives you as a defense lawyer an opportunity to speak to the people who are ultimately passing upon whether or not an indictment is going to be authorized and attempt to convince them that under the facts and circumstances of your case, it's not appropriate. Now, in the course of doing this, some of the things that, people might think about, gee, I have, my client's in ill health or something like that, or some of those kind of considerations that you might, want to talk about, say, at the end of a case, God forbid if you're at a sentencing hearing, right? They're not going to really carry much weight at the tax division conference. They're just not. And so if you're thinking about in terms of, okay, is there a way to sideline this matter? That, I think, and Paul, I'm certainly, I'd like to hear your thoughts too, but I don't think that those are very effective arguments for saying, don't bring this case, don't authorize this case against my client.
No, they're not, because, and let me just back up a step and make one other observation. If you write in and request a conference, you will get a letter that confirms your request. And the letter will say, we will give you a conference if appropriate. Now, it isn't written down anywhere when it's not appropriate. But, for example, if the prosecutors as a whole, if they think the defendant's going to flee, they may decide it's not appropriate. Now, the reality is, in these cases, the reason you wrote a letter in the first place is because the client knew he was under investigation. So, probably that's not going to occur. But every once in a while, somebody doesn't get a conference for that reason. But assuming you've gotten one, you get there, there will be one or two, usually two, tax division lawyers, and they will say, the recommended charges are, 7201 or 7206 or whatever for these years, and here's the tax loss for each year, and here's the method of proof. Specific items, net worth, which is like a unicorn anymore, but or whatever it might be. And then they pretty much look at you and say, what have you got to say? Because they will not, in general, they will not tell you, they won't tell you who the witnesses are, they won't tell you what the theory of the case is. They assume that you must know, or your client must know. And so if you're brand new to the case, it's kind of difficult because you may not know what to say. But they are very strict about the fact that it's not supposed to be a discovery process. Now, people who've been at the tax division a long time tend to be a little more loose about this because they're a little more self-confident. But you can't require them to tell you anything beyond those few things that I already said. So then if you think you have a pretty decent understanding of the case, and if you think you have something to say that may result in killing the case, you can present whatever you want. The tax division, and this is really critical, the tax division has a policy that nothing that is said in a conference is considered an admission of the taxpayer unless you hand them a document and say, this is the great exculpatory document that shows that my client didn't do anything. I mean, you can authenticate a document that way, but you can't just by making an argument about why the person isn't guilty. That's not an admission that is held against against your client. One thing you really have to think about, in my experience, is what you're going to say sufficient to kill the case, or is it just going to make parts of it go away and then leave the government with a part that's really bulletproof? That may not be the smartest move. So sometimes these conferences are a little stilted, let's just say. But you always learn something, especially if you're here in D.C., it doesn't hurt to go. They are sometimes occasionally held elsewhere. Occasionally, but that's entirely at the discretion of the government.
So let me just emphasize a couple points before we maybe move on to our next topic. And one thing that Paula said, which I do think is important, the tax division conference, while it presents an opportunity for the defense counsel, the government views this as a matter of privilege, not of right. You don't have a right to a tax division conference. So even if you sent in the letter and did everything right, if it falls through the cracks, they're going to say, well, guess what? You don't have a right to a tax division conference. I know that seems totally unfair, but that's just the way the system is, and they're always advising, as Paula said, if appropriate, too. I mean, they're always giving themselves an opportunity.
Well, and every once in a while, you get hired to represent somebody who just got indicted. So, and whoever either had no lawyer before or whoever had the client before didn't do any of these things we're talking about. And people want to say, well, can I get a conference now? And the answer is probably not, but, it doesn't hurt to ask, because the tax division, and certainly even the U.S. Attorney's offices, they don't want to do something stupid. They don't want to make a mistake. They don't want to bring a case that they're going to lose. So if you have something to say that is really titanic, that you somehow think was missed, you can think about whether you want to put it out there. Sometimes what happens as a result of a conference is that the tax division, particularly if it's a grand jury investigation, the tax division goes back to the U.S. Attorney's Office and says, well, you better look into this, that, or the other that the defendant's counsel or the putative defendant's counsel raised at the conference. And depending on what comes out of that further investigation, the case might go forward or it might go away. But they actually do listen if there's something said that's material. If you just go in and say, my client's really a good guy and he's, 80 years old and you shouldn't have sent him to jail, you're wasting your time. That's really not what it's for. And it's not to negotiate a plea bargain either.
So following up on one of Paula's points there, because I think it really is worthwhile in a what we'll call an upperclassman level here of criminal tax. If it's an administrative investigation, as I was discussing at the beginning, and as Paula said, they're becoming more rare, where the agents simply have investigated the case, put it together, and then send it to the Justice Department seeking approval for prosecution. I think there's more opportunity for the defense lawyer to make some headway in those cases. And it's not because necessarily the agent did a poor job in the investigation or didn't gather, sufficient evidence. But the fact of the matter is, no prosecutor up to that point has really seen the case. And so if you're the defense lawyer at one of these conferences, and you do have something that's very significant or titanic, as Paula was saying, you might be able to say to real prosecutors at either DOJ tax, well, in this case, we're talking about DOJ tax. You talk to them, people who've tried cases, and say, you know what, this is a real problem. And, no one really looked at this issue, and they should have looked at this issue. And you might get some, gain some ground that way, because, although the agents and the prosecutors work together and generally work together reasonably well, there is a distinction. The prosecutors are thinking about, the legality, can I prove this in trial? The agents are thinking about essentially getting the charge. Once they get the charge, the case, they've closed that part of the case and they've got their statistic, et cetera. Yeah. So it's something to really kind of consider if it's an administratively investigated case versus one where there's an actual tax division prosecutor or an assistant United States attorney involved.
Yeah. And just to close this out, I think people sometimes wonder, so, okay, I go over there and I have a conference, then what happens after I leave? What do they do? And the answer is that the reviewing attorney has to write a pros memo, and will include in the pros memo a discussion of whatever was said at the conference and why it's either worthwhile or, a waste of time. That pros memo then goes to, depending on the nature of the case, the person who ultimately has the decision-making authority for that particular case. For your average case, the decision maker is the section chief. There are 3 criminal sections in the tax division: Northern, which is essentially the Northeast; Southern, which is essentially the Southeast; and Western, which is everything west of the Mississippi. And those section chiefs can approve the average case. There are certain cases that are committed to the discretion of the Assistant Attorney General. For example, a political figure, a member of Congress, anybody like that. There are special rules for the conduct of lawyers who did something in the course of their law practice. And then so I've often had people say to me, well, can I go talk to, the Assistant Attorney General? Generally speaking, Assistant Attorneys General will not participate in conferences, or even Deputy Assistant Attorneys General. Every once in a while, there's an exception to everything. But what I've found is if you really want to get that person's attention and you somehow think your point of view isn't going to be presented, you can always send in a written submission, either before or after the conference. because then that'll be in the file, and when the files literally get moved physically from one desk to another in the tax division, then the ultimate reviewer will see whatever it is you have to say. So you can just think about how a different way to get your point across.
Yeah, and look, go ahead, Mario. Yes, is there?
Yeah.
Guess there's a question from the audience.
Yes, we have a short question from the webinar audience. It is there any value to asking for a conference if there's nothing to raise?
I've had that experience many times. I think it's a cost-benefit analysis. I mean, as I said, if you're in D.C. and it's a question of taking a cab across town and spending 2 hours, you will find out at least what I just told you. That is the charges, the dollars, the years involved, and the theory of proof. If you're going to have to fly from California to do that and you're not going to say anything, they'll probably tell you that information on the phone. So, I wouldn't do it just to spend my client's money if I really, truly didn't have anything to say. And they will tell you, in my experience anyway, I just had this happen yesterday, they will tell you the years, the dollars, the method of proof on the phone.
Yeah, I mean, I do agree with that. Paula had mentioned something earlier in her remarks when we were first talking about this, and the only other reason that you might think about, under those circumstances that the questioner raised, why you might think about having a conference, is it's dependent upon who you have reviewing that particular matter. As Paula said, you have a more senior person there who's been there, 10, 20 years. They're probably going to be a little more flexible in terms of the discussion that you have. Putting aside the normal rules that we're only going to talk to you about the proposed charges and the tax years and the tax laws. More senior people, because as Paula mentioned, they tend to be a little more confident in what they've been doing. They've been doing it for years. They might have a more open conversation, and then you might be able to, just by the nature of their questions, you might get some valuable information that way. My experience, if you're dealing with a much more junior person, they're going to stick straight to the script, and you're not going to have that discussion. They'll just say a few things and say, what do you have to tell me?
But also, let's face it, I mean, much as we like to think that all of our clients are not guilty, that isn't true. And there are cases where you don't have anything to say that will impact on the prosecutorial decision. What you have to say is the stuff you're going to say to the sentencing court or the probation officer down the road. And those arguments are not useful in a tax division conference. So it doesn't mean they're not useful at some point, but that's not the place for them.
Yeah, and so let's assume that they've actually authorized the prosecution in this particular matter. The last point I want to at least mention before we move off this topic is that don't forget, if it's an administrative investigation, or you're dealing with an assistant United States attorney who isn't actually the one who conducted the investigation, maybe they've moved on to a different job or what have you. I mean, there is the possibility when you get to that stage where the matter has been referred out for prosecution to the particular district where the crime allegedly was committed, you can talk to those assistant United States attorneys, and I have found it, at least at times, to be somewhat effective in terms of, look, this thing just kind of landed in your lap. You don't really have any connection to it. There's some serious problems. Tax crimes are very sophisticated. Heaven forbid that they would have like a method of proof that was indirect, because those are very complicated. They don't get used as much anymore. I haven't seen them that much lately. But it is a possibility that you can use the fact that the assistant United States attorney who ultimately gets this case might not have much of a connection to it. And it's just being sent and ordered by Washington. So it's something to think about, at least if you get to that stage, post-conference where the charges have been authorized. So let's talk a little bit about, let's say the case has been authorized and you're going to trial. So we wanted to talk a little bit about jury selection. We'll go through some of these policies. So look, we could spend a long time talking about jury selection. It's obviously there are courses, committed just solely to that topic. What I wanted to raise was one particular issue in jury selection with respect to criminal tax cases, which I think tends to get a little more focus by both the prosecutors and by both defense lawyers. So you can see, I mean, I've listed out some of the things that, common considerations that you always have in terms of how do I select my jury? Is there any benefit, based on gender or, religious status or marital status or education or anything like that? You're always going to have those considerations as you think about your case, what the charges are, who your client is, etc. One thing that does tend to come up, I think, in criminal tax cases, more frequently maybe than in other cases, is a focus on the employment of the prospective juror. I can't tell you how many times, and Paula might have a differing view on this, but I can't tell you how many times it's been shorthanded to, well, if you're the government, you want someone who is a quote-unquote W-9 taxpayer, someone who's employed, who, the taxes are taken out of their paycheck, every other week or so, and there's really not much ability, if you will, or opportunity, maybe is a better word, for them to potentially, fudge on their taxes. Now, on the other side, you'll hear defense lawyers sometimes say, well, I want someone who's like a small businessman who operates, maybe a sole proprietorship or a small proprietorship. Because conversely, when you're figuring out what are my deductions, do I have to put everything that came into the cash register on my sheets, etc., there would be more opportunity for them to potentially fudge. And so these are like rules of thumb. And I'm not saying that it's not a consideration, something to think about, but there is one, I will give you we don't do a lot of war stories, but I'm going to give you one, and this goes back to my days as a prosecutor, not as a defense lawyer. And it came after a relatively, they don't happen that often, but it was an acquittal. And I was the chief of one of the sections that Paula was talking about. And I had the prosecutors into the office and I asked them, well, what happened? How'd it go? What was going on? And a very senior prosecutor, no names, said, well, we thought we had a really good jury pool. We had a lot of W-9 taxpayers on it. And my next question is, well, okay, but what did they actually do for a living? And the response was, well, he was a professor of sociology at the local university. And I said, well, did that give you any pause? It's like, well, no, he's a W-9 wage earner. And I said to him, well, I understand the point, but if we're, and again, as a former prosecutor, if we're looking at this and trying to convince a jury of the defendant's peers that they committed a crime and assess liability for their individual actions, I said, I'm not sure that this would be particularly the best person to put on your jury. And I said, by the way, don't tell me, but I'm assuming that person was also the foreperson. Oh yeah, how'd you know? Yeah, well, because he was a local professor, and people would tend to look at a professor as someone, who's knowledgeable and wise and reasonable. So I won't. I could go into the teacher would too, because I will actually. I'm going to give me 2. I'm going to do 2 minutes. So I then asked, okay, who else did you have? Okay, we had a teacher. I said, well, okay, I don't have nothing against teachers. I just said, what grade did they teach? I think it was like first grade, kindergarten or first grade. I said, well, did that cause you any pause? No, I mean, they were, W-2, they were, they're getting their paychecks. And I said, look, my view, and again, this is all my opinion. You guys could say, Tom, you're crazy. I don't buy that for a second. But my view was, look, when you're teaching kids at that age, and I have kids, and it's like, look, they're really super cute at that time. And the world is totally open, and every kid in your class can be the next president or an astronaut or whatever. So it's a very optimistic view. And as a former prosecutor at the time, I said, but you're asking the jury to do something that's kind of difficult, right? You're talking about finding someone liable for a crime, and while you're not the one who actually sentences that person, you understand that your actions might cause that person to go to jail. I said, those, people who, my view, people who would, who are around that kind of optimistic, young children at that age, I'm not sure that's really the best choice. Now, for the high school teacher, I think they've seen kids in high school, you can see, they're getting older and things like that. So I don't have any rules against, teachers. It sounds like I do against educators, doesn't it? I talk about but remember, that was my old job. But I'm just saying there are thoughts, and people can disagree with this, but if you hear people in criminal tax cases start talking about, well, there's this rule of thumb, they're W-9, so I really don't have to think that much more about it, give it a second thought.
Well, I'll just chime in briefly because this is a very complicated subject, and my experience is that, first of all, you don't get to pick the jury you want. You get to exclude the jurors you most don't want. And you don't get, in my experience, you don't get very many teachers because judges are very willing to excuse teachers, unless it's the summertime or something. You also don't get very many self-employed business people because they say, if I'm not there, my business shuts down and, my family starts to go hungry, and judges will tend to let them go. So, and especially around here, you tend to get a lot of not only W-9 employees, but government employees who are not going to be excused just because they work for the United States government. So it's really a question of trying to get as much information as you can about the individual person, and to do all the stuff that we try to do in the, jury selection goes boom, 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 boom. So you look at, what kind of tie is the guy wearing? Is he wearing a tie? What kind of T-shirt what kind of logos on their T-shirt? What book did he bring in with him or whatever? And when they answer the judges' questions, how do they behave? But it is truly, truly an exercise in instinct and, hope. That's all I can say. I mean, I think it's a very, very hard thing. Having said that, I do believe that people try to do what they're supposed to do when they serve on a jury, and I think they try very hard. And so you got no matter who you get, you have to go into it, open-minded that they can see both sides of the argument.
So to keep things moving, let's now turn to the issue of expert witnesses, and I think Paula's got some thoughts she might want to share, and I think I might chime in a bit.
Okay. Well, this is something, unlike talking about what happens at jury selection, there are certain sort of reliable things that you can predict are going to happen at every criminal tax trial. And first of all, tax crimes don't get prosecuted unless there is a tax loss. Technically, it's the same crime to file a false tax return, whether the bottom line changes or not. It's the same crime to fail to file, whether you owe any tax or not. But the reality is that people don't get prosecuted unless there is a tax due and owing, because juries think you're wasting their time, among other things, if there isn't any. So the government always puts on somebody to say, here's the tax consequence of whatever this submission or false submission was. It's not an element of the offense, except in an evasion case, but nevertheless, they always put somebody on. And I think there is a popular misconception that witness is likely to be the special agent who investigated the case, which is not so. And there are a lot of reasons for that. First of all, the special agents are criminal investigators. They're not revenue agents. They're not green eye shade types. And they don't necessarily make the best witnesses. The second thing is they're biased. This is their case. They've spent a lot of time working on it, and smart prosecutors don't want to put up a witness who's going to be subject to that cross-examination. Not only that, if that person testifies, his SAR then becomes Jenks material. And smart prosecutors don't want to be giving the SAR out in most cases. So the IRS has, and I don't know if they're formally designated in their job title as this, but they have people within the IRS who are generally revenue agents, who they are sort of their go-to people to testify in tax cases to put on the computations. And they can either be designated as experts who have to go through all the same expert disclosures and expert qualifications as anybody else. Or sometimes what you see is that the IRS will say, well, they're not an expert, it's just a summary witness. All they're doing is adding things up. And I think you have to be pretty vigilant about that because, for example, in a regular fraud case, a summary witness who says, yes, I've reviewed all these invoices that add up to X, and they add up to X, fine. And then you can cross-examine about whether they considered all the right invoices or whatever. But once you go from it adds up to X, and then the tax liability of X is Y, you are applying a degree of expert knowledge to that the ordinary person doesn't have. And so you might want to challenge that testimony based on the fact that the summary witness is doing something that goes beyond the summary function. On the other hand, if the person is an expert and is duly qualified, they can do that to a point. What you see sometimes is, and I had a case, I'll tell you my little war story. I had a return preparer case where my client was accused of filing tax returns for people that took all sorts of fake deductions for, business expenses and charities and medical and all that. And the government filed an expert disclosure that said, we're going to call revenue agent so-and-so who is going to explain to the jury what the tax law provides with respect to business deductions and charitable medical. And I was like, no, you're not. You're not going to sit there and have some revenue agent explain to the jury what the law is. And I filed a motion in limine, and the judge basically in about 2 seconds said, not in my courtroom. I'm going to explain to the jury what the law is. And the prosecutor said, you mean I have to write jury instructions for each one of these things? And the answer was, yes, you do. Now, it's hard to say, if all you're doing is adding up let's say that's, a specific items case. If all you're doing is adding up the specific items and saying the taxpayer had an extra $1 million in taxable income, and that translates to Y in tax, maybe that isn't very sophisticated. But if he's going to make a whole bunch of assumptions about why something is taxable income, you can kind of get into that. But I think you have to be very careful that the law should come from the court. The law should not come from the witnesses. And I think there are a lot of prosecutors who try to sort of put the revenue agent, it's not a special agent, put the IRS expert on to say things. The other thing that an expert can't do in a tax case is to opine about the state of mind of the taxpayer. I think this conduct was willful. That's not something you're qualified to opine about. Or conversely, for the defense to put on an expert to say, I don't think the conduct was willful. I mean, that's the ultimate issue in the case. And the court will instruct the jury how it decides willfulness, but that's not something that an expert is particularly entitled to opine about. I mean, I saw an expert disclosure a couple years ago in a case we had that was just unbelievable. It was just full of all this kind of stuff. After motions, it was considerably whittled down, but if we hadn't challenged it, I suppose that's what the prosecutor intended for this witness to say. And that is completely unacceptable as a way of expert testimony.
So I think what Paul is saying is the further they get away from being
bean counters,
being a bean counter, being essentially a human calculator with respect to the evidence that's been put in. And in tax cases, it can be substantial if you're going through lots of invoices and things like that in terms of billing. The further they get away from being that bean counter human calculator towards opining on, either this is what they must have believed or making those kind of assertions, then you've got a problem. And Paul, I think there's a way, sometimes just the way they're quote unquote qualified might be worth at least talking about a moment.
Well, as I said, if the person's identified as an expert, then they have to be qualified. I've been a revenue agent and I've gotten all my training, yada, yada, yada. If they're a summary witness, what difference does all of that make? I think the reality is, I would object. I think the reality is most judges will let a certain amount of that come in anyway, just to sort of support the general credibility of the witness. But too much of it is really unnecessary, and it's prejudicial to the defendant. All you're doing is purporting to, anybody can be a summary witness, anybody. So the fact that you may be, you may have gotten the IRS Agent of the Year award doesn't really make any difference. But naturally, they want to build up their witnesses. One other area that I wanted to just touch on, and I don't want to spend too much time because it's pretty complicated, but if you have this issue, There are a few cases out there, and they're mentioned in the materials, where the law was very uncertain about whether a particular thing constituted income or not. There's a famous case called Garber that we've cited, which dealt with a woman who was selling, she had very rare antibodies in her blood, and she was selling them and making a whole lot of money. And like, who knew? What, is this income, is this not income? And of course it is income, but proving that she knew that was an issue. And there's a lot of debate in the Garber case about whether that is expert testimony that should be allowed before the jury, or whether it's really an issue for the judge. I tried a case a few years ago which dealt with one of these issues of first impression, and we addressed all our arguments to the judge, which is that the law was so uncertain that as a matter of law you couldn't form the specific intent to violate it, which I think is the better approach rather than having dueling experts. But there are at least some cases where some expert testimony on that kind of issue has been allowed.
So unless there are some questions on the use of experts or summary witnesses, I think maybe Paul and I will turn to the last topic that we've selected, and that deals with restitution in tax cases. And so, Paul, I know you have some recent experience in this area.
I do. And I'll try to make this succinct because I think it's a little bit complicated, as all restitution is, and maybe it's just slightly more complicated. In general, the Mandatory Victim Restitution Act, which governs all Title 18 offenses, does not apply to tax cases. So if you represent somebody who gets indicted for a tax crime, goes to trial, and gets convicted, it will not be part of that person's sentence that he pay restitution to the IRS, because it's not part of MVRA. Now, if he's charged under a Title 18 tax offense, for example, 287, which deals with 18 U.S.C. 287, which deals with false claims for refund, it could be. But in general, that doesn't apply. However, the statutes, and this is under 3663, and I guess it's 3664, provide that a person can agree in a plea agreement to pay restitution, and I can guarantee you that if you have a tax plea, the government will insist on an agreement to pay restitution. Restitution can also be imposed, even in a non-plea situation, as a condition of probation or as a condition of supervised release. So the tax liability is going to be dealt with one way or the other. When I started doing this work a very long time ago, the civil and the criminal parts of tax never met each other. The criminal process went forward. There was a tax number that was talked about to make the judge think the guy should go to jail, but whether and if and how it was ever collected wasn't really the criminal people's issue, and they really didn't think about it. And then you did your time, and then a couple years later you dealt with the civil part of the IRS. That is really not true anymore. There's a much, and frankly, it's from a prosecutor's point of view, it makes sense because they want to make sure that they get the money as much as possible. So the plea agreements will require it. And then the court can impose it, as I said, as a condition of probation or a condition of supervised release. There is a statute that's part of the Internal Revenue Code that is fairly new, that it provides for what's called restitution-based assessment. It's Section 6201 of Title 26. And without getting too far into the weeds of civil tax procedure, which is pretty complicated, an assessment is a term of art in the tax law. And in essence, it's like the equivalent of a judgment in civil practice. And it's when the IRS enters on its books that the taxpayer owes a particular amount of money. And only after an assessment has been made can the IRS use all of its various remedies to attempt to collect it. Normally, the IRS can't make an assessment until it sends a taxpayer a notice of a proposed assessment, and they have the opportunity to challenge it in the tax court, and on and on and on. A restitution-based assessment circumvents all of that. Once the court determines the amount of what the restitution should be, then the IRS will make a restitution-based assessment. And the taxpayer cannot argue about it anymore, can't challenge it. But it is not necessarily the entire exposure that the taxpayer has to the civil tax authorities. There are cases where you have what's called a criminal number. So let's say somebody, did a particular transaction where he sold a big piece of property in 1 year and he made $1 bazillion and he didn't report it. And that was the subject of the criminal case. That will form the basis for the restitution-based assessment. But let's say after the IRS audits the person's tax returns, they also found out he was taking a lot of bad deductions for like travel and entertainment expenses or something, maybe questionable charitable contributions, that kind of thing, that would generate an additional tax liability. The IRS can do that. The IRS can go after it, subject to the ordinary civil tax processes. And I think there's just a lot of confusion about this because the restitution-based assessment, once you enter into a plea agreement and once the court enters the judgment commitment order, that's pretty much done, and the IRS will come looking for the money. Restitution-based assessments, like all other assessments, generate interest, which runs from the time the tax should have been paid until the time it is paid. And right now, I think, what's the interest rate right now? About 4% compounded daily. So interest rates can be a lot. The restitution-based assessment can only really be for the tax unless you agree to penalties in the plea agreement. And a lot of prosecutors will try to get the taxpayer to agree to a civil fraud penalty, which, if you have pled guilty to the crime of tax evasion, you are collaterally estopped from denying civil fraud anyway. Once an assessment is on the IRS's books, it's good for at least 10 years. And that 10 years can be extended by a variety of different circumstances, like leaving the country or filing for bankruptcy or assorted other things.
So if I just might jump in.
Yeah.
So, kind of to summarize what Paula is saying, and she's done an excellent job of kind of setting it forth. Just because there's, this restitution-based assessments made doesn't necessarily mean that that's the end of the story. And it's a potential pitfall if you're representing a criminal tax defendant in one of these matters, and they think, oh, well, that's it. I understand. I might have to, whether I have to do a period of incarceration or whether it's probation, whatever. I get that. And here's the number that ultimately I'm going to be tagged with in terms of what I'm responsible for paying back. But it might not be so.
Right.
And you don't want your client coming back to you saying, what they just assessed me another $1 million. What am I supposed to do?
Well, and there's another point that I think is worth mentioning, which is, look, if the ideal world if you do get caught and you do decide to enter into a plea agreement, the ideal world is to pay your tax liability before you are sentenced, because obviously that's when you get the most bang for the buck out of having done it, and judges really like that. And if you can't pay all of it, you pay as much as you can pay. And whatever is paid obviously will be offset to the restitution-based assessment. But in the ordinary tax world, the world is full of people who have tax liabilities they can't pay and will never be able to pay. And interest is cranking along faster than they can pay. There is an IRS process called an offer in compromise, which is basically, you cut a deal with the IRS. Sometimes it's 20 cents on the dollar, sometimes it's 50 cents on the dollar. There's no rule of thumb. It's a function of what the taxpayer has. It is excruciatingly difficult to negotiate an offer in compromise, but it does happen. And so people who have these I've had a client who has a restitution-based assessment of $16 million. He can't live long enough to pay it. And so the obvious question is, well, can I have an offer in compromise with the IRS? And the answer is no. And the IRS has, the citation is in the materials, the IRS has, as a matter of policy, announced that it won't do that. And really there's a statutory reason for it too, which is that once the court has entered a restitution order, the authority to modify that restitution order remains with the court, not with any other party. But you can have this sort of competing, because all the U.S. attorney's offices have forget what they call them, judgment and collection units, I think, that try to collect restitution that's ordered in their cases. So you can have those people looking for your client, and you can have the IRS collection people looking for your client. And, there's only so much blood that can be obtained out of the stone. And I think for somebody who's been through the criminal process and hopefully done their time and trying to get their life back in order, realizing that these civil liabilities are going to follow them around for years and years and years is really difficult. And I'm not saying you can always change it. Sometimes you just can't. It depends on whether they ever have enough money to get rid of it. But at least they can understand what's involved. Because telling them that once they walk out of the courthouse at sentencing, that's over. That is just not the case. Wait a minute, there was one other thing I wanted to say about this. Let's see what it is. Maybe that was it. Oh, yes, I know what it is. There is a provision in the restitution statute that applies to all cases, not just tax cases, but that says that if figuring out the amount of restitution is too complicated and the difficulty of doing it outweighs the need to provide restitution to a victim or victims, the court can decline to do that. And I actually had that case happen in one of the big criminal tax shelter cases in New York. The case that's in the materials, which unfortunately is not in Westlaw, but you can get the decision off of Pacer if you want to, involves a return preparer case in the District of Maryland, where the court was very concerned. It was a return preparer case, and as you probably know, a return preparer can be held liable for the tax liabilities of his clients arising from the bad tax returns that he paid or he prepared. And so, but the taxpayer remains liable for the tax. So the court got very concerned that, well, what's going to happen if the taxpayer pays the tax, and how is the IRS going to offset that against the restitution that the court was being asked to impose against the return preparer? And I have to say the government didn't provide very good answers about how all this was going to happen. And as a result, the judge said, I'm not going to order any restitution. The IRS can go get it from the taxpayers. That's probably an unusual judge. And because in all return preparer cases that I've had, the IRS I had one case where they said, we don't want any restitution because the taxpayers have all paid, which I found personally highly unlikely. But I think it was that the prosecutor just didn't want to go through all this complicated analysis. But most cases, they know that the taxpayers probably aren't going to pay, and they do want the return preparer to pay. So they will be seeking a restitution-based assessment. But if you're representing the return preparer, you might want to think about this argument that, and read this opinion about how complicated it can become.
So I think, one last point maybe to make here, and I kind of want to circle it back to something that we started the discussion off today with. Paul has been very good about focusing on the restitution issue because it does create all these issues. But as she was discussing, there are these civil tax liabilities out there, and it's something that maybe people who are newer to this practice area should pay attention to. When I started at the beginning and told you, look, they're going to give you, when you go into a conference, they'll tell you, here are the proposed charges, and here's how we're proving them up, the method of proof. But we're not going to give you discovery, and we're not going to discuss civil compromise of taxes. That's really what that's a big issue, right? Let's assume for a second that we're not even talking about the restitution issue. Paula referenced this earlier in her remarks. Most prosecutors are looking to make their case as streamlined and as bulletproof as possible. And so you're going to hit the big taxable items that have not been reported. I think you were using the example of a piece of real estate or something like that. And so that's going to be the focus of the criminal investigation that the special agent's done. And so some people who are new to the area might think, well, that's the sum and substance of what this person has potentially hanging out there in terms of the dollar amounts. Putting aside the guidelines impact of that, just in terms of, okay, what's the civil tax liability? They're thinking, okay, well, it's $1 million. Well, it very well might not be, because the IRS is still open to the IRS to do a civil examination, to find additional items of income that weren't reported, and to assess on those penalties, interest, et cetera, like Paula was talking about. And you might have a much greater tax liability for your client than you would have ever anticipated at the beginning of the case when the criminal charges were first being discussed. Because nothing stops them from going back and saying, yeah, but you inflated those deductions, and oh, by the way, I found out you had another piece of property over in in an offshore jurisdiction. So that's something to keep in mind, that those civil liabilities remain outstanding. Now, does the service generally have the resources to go do that? Do they want to?
I would say it's very hit or miss. The statute of limitations is forever in the case of fraud. And obviously, if you had a criminal tax case, that usually implicates fraud. I had a case last year involving a woman whose husband had pled guilty to tax evasion and was since incarcerated for another significant crime for events that happened in the year 2000. And in 2015, the IRS came to her, well, the husband too, except he's in jail and will be in jail forever, and said, oh, you all, as part of your joint tax return, owe another $250,000 from the year 2000. And we got all this information from the criminal investigators. We just finally got around to looking at it. And I was fortunately able to make that go away, but I was just stunned, frankly, that they had resuscitated this at that point. And of course, by then you can imagine people don't have records and witnesses aren't around, and it's very difficult. And the IRS is in a somewhat dysfunctional state these days, shall we say. And so, you can't say in a particular case they either will or will not follow up.
But you need to be aware of it.
Right.
So, Mario, you
We
said
have 3
we have a couple minutes, I think, for potential questions.
Yeah, this time we're going to open it up for questions. We have one additional question on that came in through the webinar, and I'll just read it. It goes back to the issue of the tax conference. It goes back to the issue of the tax conference. It starts, good afternoon. In 2015, I had a conference with tax division over an administrative case in which a set of charges were proposed by the IRS. Co-counsel and I submitted briefing letters and arguing against the proposed charges were granted a call, and the tax division agreed with our position. A few weeks later, tax division authorized a second, different set of charges and refused to grant us another conference. Is this bait and switch tactic typical of the new DOJ?
The new DOJ, as opposed to the one I was involved in? You can answer that.
Look,
That's unfortunate.
yeah, that is totally unfortunate. I mean, look, my view, maybe I'm a little, some people might say naive. Look, I generally think the people over at the Department of Justice Tax Division are trying to do the right thing. I don't think they're trying to necessarily play games, to sucker people into those things. Could I say that that never occurs? Of course not, but.
Well, but it also, I think, is a function of what I said at the beginning of this, which is you have to consider whether what you're going to say is going to kill the case or just make them think of a way to make it better. And without knowing the specifics of the questioner's circumstances, I don't know exactly. But let's say, for example, you convince them they shouldn't bring an evasion case because there is no tax liability or something, but they can bring a conspiracy case. Great, you won the point, you won the battle, but you lost the war.
Or 72061, which happens all the time during the review process.
Right.
If there's some question about the ability of the government to prove the tax deficiency, oftentimes the fallback is to charge under 72061, which is a material false statement on the return, and you don't have to, as an element of that charge, prove a tax deficiency.
Yeah. So I would say if the circumstances involved a different set of charges arising out of the same set of facts, I mean, clearly it would be nice if you'd be allowed to address whatever the other statutory basis is. If it's a different set of facts, then I'd go back and complain up the chain.
Okay, all right. I think we have time for one last question. And this is, will a satisfaction of judgment of the restitution bar IRS from collecting interest not included in the restitution order?
No.
Well, that was quick and easy.
There's case law on that, which is in the materials.
Okay.
Okay, thank you. I think that concludes our NACDL summer series, and I would like to thank our panelists for coming in. If I could do one last plug for our White Collar Conference in Washington, D.C., I think Koichi is posting it now on the web. It is Thursday, October 27th through Friday, October 28th. Please check online, and as always, stay tuned for more excellent programming coming from NACDL, or visit our website. Thank you all.
Thank
Okay.
you.
Thank